Hello everyone. So this is the second video of the polity discussion. Okay, so we are doing this entire political science syllabus discussion for the prelims 2026 on the basis of the Shankar IAS prelims test. Okay, so till the 11 questions we have completed our discussion till 11th question. Now from 12 we are going to start today. So consider the following features. Okay, how many of the features mentioned above are common to both the Indian and the British Constitution? Okay, so you have to just choose how many of them are common to Indian and British Constitution. So let us discuss one by one. So first is the parliamentary sovereignty. So you know that the parliamentary sovereignty is basically there in the UK. Why? Because it is the parliament which has the power, or which has the supreme, or which has the power to make the law. Okay, it has the supreme authority of making the law. Okay, so that means that parliament, there is no authority above the parliament in the UK, whereas in India there is a parliament is not sovereign in the sense that its power are limited by the constitution. Okay, so that is why you don't have parliamentary sovereignty as common as one of the common thing between the UK and the and India. So this is wrong. Now let us see the republic polity. Now what is republic polity? Republic means the head of a state is elected. Okay, and there is a absence of any kind of privileges. There is a no rule of the king. Okay, so that kind of things will be a part of the republic polity. So in India, you know that the head of a state is the president who is elected. So India is a republic, but in UK is not republic. Why? Because head of the state is not elected, rather it is hereditary in nature, because there is a monarchy system that is prevalent in the UK, where queen or the king is succeeded by his or her son. Okay, so that is the thing. So 2 is also not the correct. Now let us see the statement on number third, that is the collective responsibility of the executive to the legislature. Now collective responsibility of the executive to the legislature, yes, this is the common thing to both the countries. You know, in UK, it is the collective responsibility of the executive, means council of ministers, to the legislature, that is the House of Commons in UK. And this is also prevalent, this practice is also prevalent in India also, because the council of ministers, which is the executive, is responsible for its acts to the legislature, that is the Lok Sabha. Okay, this question has already been asked by UPSC, this particular, on this particular, that the council of ministers is responsible to which of the following house, or which of the following things. Okay, so collective responsibility of the executive lies to the legislature, in Indian context to the Lok Sabha. Okay, so one is correct. So this three statement is what is common between these two nations. Okay, now let us see written constitution. Though India is having written constitution, but there is a no written constitution on the on the British context. Okay, in the British context. Why? Because Britain practice what we call that the conventions, or there is a system of conventions. Okay, or the what they get from their producers. Okay, like so they don't have written constitution as such, but they follow the tradition or the conventions for where they have, you know, certain things to be decided as, or as the rights, or as the duty of the state, or the duty of the citizens. Okay, that is how they function. Okay, basically precedent, if something has happened earlier, then that thing will be applied to any event which is happening right now or the in the future. Okay, that is called the precedent. Okay, that is how they are working. Okay, so written constitution, there is a no common thing between these two countries. Hence, the statement 3 is only correct. Okay, so that is what we make to opt for option A. That is the only one of the features above given is common between both two Indian and the British constitution. Okay, So let us see the explanation. Okay, so parliamentary sovereignty in the UK makes you parliament the supreme legal authority. I told you, able to make or change any law. Courts cannot overrule their legislation, and no parliament can bind future parliaments. In India, parliament is not sovereign. It works within a written constitution, which is the supreme law. Its powers are limited by division of powers between the union and the state and by the fundamental rights. All laws passed by parliament must follow the constitution and are subject to judicial review by independent courts. This ensures a balance between parliamentary authority and constitutional supremacy, preventing unconstitutional law. Mechanisms like the basic structure doctrine Keswananda Bharti case ensure that even constitutional amendments cannot violate fundamental principles. This affords the constitution supremacy while allowing parliament to legislate within limits. Thus, unlike the UK Parliament, parliamentary sovereignty does not exist in India in purist form, and the Indian Constitution ensures a balance between the parliamentary sovereignty and constitutional supremacy. So, statement one is not correct. Now, for statement two, let us see. A democratic polity can be classified into two categories, that is, monarchy and republic. In monarchy, the head of a state enjoys a hereditary position, that is, he comes into office through succession, for example, Britain. In a republic, on the other hand, the head of a state is always elected directly or indirectly for a fixed period, for example, India. Therefore, the term republic in our preamble indicates that India has an elected head called the president. He is elected indirectly for a fixed period of 5 years. A republic also means two more things. Um, vesting of political sovereignty in the people and not in a single individual like a king. Second, the absence of any privileged class and hence all public offices being open to every citizen without any discrimination. Therefore, the republic polity is not common to India and the British Constitution. Now, let us move ahead. So, the collective responsibility of the executive to the legislature is common to both India and the British Constitution. It is bedrock principle of the parliamentary sovereignty. I think now it is fine, but we can't see everything. Just let me just once. Yes, it is the bedrock principle of parliamentary government. In Britain, the cabinet is collectively responsible to the House of Commons. For example, if the House of Commons withdraws support, the government falls. In case of India, the ministers are collectively responsible to the Parliament in general and to the Lok Sabha in particular. Article 75. They act as a team and swing together, sing together. And the principle of collective responsibility implies that the Lok Sabha can remove the ministry, that is the Council of Ministers, headed by Prime Minister, from office by passing a veto of no confidence. The Indian Constitution is not only a written document but also the longest constitution in the world. It specifies the structure, organization, powers, and functions of both the central and the state governments and prescribes the limits within which they must operate. Unlike India, the British Constitution is not a single written document. Instead, it is a collection of various sources such as customs, traditions, judicial decisions, statutes, laws made by the my parliament and historical document like Magna Carta. Okay, so British Constitution is not a single written document. It is a collection of various sources such as customs, traditions, judicial decisions, statutes, laws made by the parliament, and historical documents. I told you na, precedents, historical documents are like Magna Carta. Now, question number 13. Article 20, Clause 1 states that no person Article 20, Clause 1 states that no person shall be convicted of any offense except for violation of office in force at the time of the commission of the act, charged as an offense, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of commission of the offense. So this is the example of prohibition against X post facto legislation. Now, what is ex post facto legislation? Let us see. So, Clause 2 of Article 20 of Indian Constitution deals with the provision against double jeopardy. The doctrine of double jeopardy traces backs its origin to the American jurisprudence of punishment, and means no person can be prosecuted and punished twice for the same offense. Okay, so you are committing uh, any offense for two times, then you will be given only at a punishment at a for one time. Okay, for one thing, not twice for the same kind of punishment. Okay, Article 22 reads that no one could be convicted and punished more than once for the same offense involving the same set of facts. In a sense, it guarantees against the multiple conviction of a person for the same offense in the same set of facts. Clause 3 of Article 20 of the Indian Constitution deals with a provision against self-incrimination. It is said that no person accused of any offense shall be compelled to a witness against himself or herself. The right against self-incrimination has existed since medieval times but gained importance in modern times as well since its development in common law countries. This right was started to be considered an essential right and one of the important facets of the principles of natural justice. Clause 1 of Article 20 of the Indian Constitution deals with the provision against ex post facto law. Basically, ex post facto laws are those laws which penalize individual for acts that were lawful when committed but subsequently declared unlawful by a law enacted later on. Thus, illegal actions done in the past cannot be retrospectively criminalized by a subsequent law. Rather, new laws can only be applied prospectively. Article 21 states that an individual cannot be persecuted and convicted under those laws that were not existence in at time the offense was committed, nor can he be given a punishment greater than that existed at the time of commission of an offense. So option C is correct. Article 22, clause 1 and 2 of the Constitution of India provides protection against punitive arbitrary arrest and detention. No person is arrested. No person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest, nor shall be he denied the right to consult and to be defended by legal practitioner of his choice. Consider the following. The state legislature prescribed residence as a criteria for the appointment in employment under the state government. Yes, this is the correct. The state, for example, the Haryana or the Bihar, let us take the example of Bihar state legislature that has prescribed the residents, which means that those who are born or those who are who is having the domicile of Bihar will have certain percentage of what of reservation in the Bihar Public Service Commission. Okay, vacancies. Okay, so that is the thing. So that can be done by the state legislature. Okay, so second, the state legislature prescribed religion as the criteria for appointment in the employment under the state government in an office connected with the affairs of the any religion. No, this is not correct. Okay, because state cannot interfere in the any religious or denominational denominational institution. Let us explore. So one is correct, hence. Now explanation. So Article 16.2 guarantees equality of opportunity in public employment and prohibits discrimination based on what residence or place of birth. This means that in general, no citizen can be denied a state job simply because they do not live in a particular area. Okay. The only exception is under Article 16.3, which allows the state to prescribe residence for certain local posts where the duties are confined to a specific area. However, the Public Employment Requirement as to Residence Act 1957, which allowed residence requirements, expired in 1974, except for some provisions in Andhra Pradesh and Telangana. Therefore, if a state imposes a residence requirement for general employment outside these local exceptions, it violates Article 16 because it constitutes arbitrary discrimination. So statement 1 is correct. Article 16 of clause 4 explicitly allows the state to make a special provision for the employment in offices connected with religious or denominational institution, which can include requiring employees to belong a particular religion or denomination. This exception exists because certain offices, such as those managing temples, churches, mosques, or other religious institutions, may require employees to follow the path of institution to properly perform their duties. Since this is a constitutional exception, prescribing religion for such posts does not violate Article 16. Now, additional information. Now, exceptions under Article 16. Exception: reservation for backward classes. The state can reserve jobs for backward classes that are underrepresented in state services. Reservation can also apply in promotions with seniority considered. Unfilled reserve vacancies in a year can be carried forward as a separate class of vacancies to the next year. These carried forward vacancies do not count toward the 50% reservation ceiling for that year. Religion-based appointments. A law can require that office bearers in religious or denominational institution belong to that specific religion or denomination. In short, religious qualification can be prescribed by law for such positions. Reservation for economically weaker section. The state can reserve up to 10% of jobs for economically weaker sections. This 10% is in addition to the existing reservations. EWS groups are notified by the state based on family income and other indicators of economic disadvantage. Now, question number 15. Consider the following government initiatives. How many of the above digital initiatives are related to the transforming the public distribution system, which is PDS in India? So, so only three are correct. I don't know about these things. Let us see explanation. So, the Union Ministry of Consumer Affairs recently launched a set of digital initiatives to transform India's public distribution system (PDS), enhancing transparency, infrastructure, and empowerment for beneficiaries and frontline workers. The three main platforms are uh, Depot Darpan, Anna Mitra, and Anna Sahayata, aim to streamline the delivery of subsidized food grains to over 81 crore people under the National Food Security Act.